Tonight begins with the passing of former Chief Justice of Nigeria, Ibrahim Muhammad, popularly known as Tanko Muhammad. The former CJN died at the age of 71 in a hospital in Saudi Arabia, where he had been receiving medical treatment. His death was confirmed by the Nigerian Association of Muslim Law Students in an official condolence statement issued from Abuja. The association described his passing as a major loss to the Nigerian judiciary, the legal profession, the Muslim community, and the nation. It also extended condolences to his family, the judiciary, the federal government, the people of Nigeria, and the wider Muslim community at large. Muhammad served as the substantive CJN from July the 24th, 2019 to June the 27th, 2022 as Nigeria's 17th Chief Justice. He was appointed acting CJN on January the 25th, 2019 in controversial circumstances after the suspension of Walter Onnoghen, his predecessor. In January 2019, then President Muhammadu Buhari suspended Onnoghen over allegations of non-asset declaration. In June 2022, Muhammad resigned as Chief Justice of Nigeria on grounds of ill health. Let's cross live now to our Abuja studio, where a senior advocate of Nigeria, Sam Kargbo, is waiting to discuss with us the life and times of the late Chief Justice and how the judiciary fared under him. Thank you very much for being here.
Thank you very much for having me.
All right. He progressed from the Sharia court to become the Supreme Court Justice in 2006. What role do you think his educational background in Islamic and common law played in shaping his judicial philosophy?
I wasn't really surprised that his death was announced by his community, which is the Islamic law community of the judicial system. But let me put it this way. Ibrahim Tanko Muhammad, that's what he liked to be called, although he was popularly called Tanko Muhammad. It was a typical judicial officer. He started very early in life, just about under 1 year post-call. He became, what do you call it now, a magistrate grade 2. The very beginning, he started as a magistrate grade 2, and within 10 years, he had risen to the Court of Appeal. And that is between 1981, when he was called, to 1993, he had served as a judge of the Sharia Court of Appeal, which actually gave him the foundation for him to be appointed to the Court of Appeal, because usually there is always a slot for somebody who is knowledgeable in Sharia law to be appointed as Justice of the Court of Appeal and the Supreme Court. That trajectory and that route helped him to access both the Court of Appeal and the Supreme Court. And from about 1993 to 2007, when he got into the Supreme Court, he was at the Court of Appeal for about, if my math is right, I think 13 years. He was at the Court of Appeal. And from 2007 to 2022, he was at the Supreme Court. That tells a lot, meaning that all his active and post-call to the bar life has been on the bench. And that means a lot. Okay. A lot in the sense that he actually had the sixth sense of the judicial system and the judiciary from about the 1982 to 2022.
All right. His career part is something that a lot of persons have admired. Some say it's a bit controversial how he moved from in the judicial space. But I want you to talk to us about what you feel is his legacy to the judiciary. Is there perhaps any particular reform or policy that came under his watch?
You know, let me put it, it's difficult to actually itemize his legacy, but mind you, he came at the thick of election petitions, and for anybody who preside over any round of election petition, usually either left or right, your name would be part of the history. As at the time Onnoghen was eased out and he came, I wouldn't say he wasn't prepared for it, but he came at the thick of elections. And that was the time we had cases like that of the case that brought in Hopu Sodima, which today many people misconstrue. And there is a lot of debate over the rightness or wrongness of that decision. And he presided over the court at that time. Many people still believe that, oh, it was the Supreme Court that actually appointed Hopu Sodima. But those of us who are lawyers who know what actually transpired and the issues that were presented before the Supreme Court, we thought that judgment reflected the facts of the case and the adversarial prowess of the parties that were before the court. So if you are asking me about his own legacy, yes, that was it. And also because of his background as a Sharia judicial officer and knowledgeable in the Sharia law, which is why he actually rose methodically and over and above his peers. I think in one of the landmark judgments, that of defamation in the Sharia law, there was that challenge of navigating between the jurisprudence of Sharia law and the Constitution itself that tried to insulate, what do you call it, religion from the everyday life of Nigerians.
Okay, I know you've highlighted a bit of that, but we do know he faced a lot of criticism over judicial independence at the time, and then there were talks about internal divisions within the Supreme Court. Based on what we know about him and his time there, what would be your reflections on how he handled those criticisms and if he did anything to address it?
Well, he was taciturn. He was not a talker. He was not one that could respond. If at all, many a time he had people representing him at public fora, and it's difficult to quote him on anything. But as you rightly said, his tenure was unprecedented in the sense that from the word go, it was a roller coaster of challenges. His colleague was pushed out before his tenure, and he got into the office. Other people would have thought that the Supreme Court should, as a unit, rally around one of theirs. But I think the decision then was that, the lot was for Onnoghen to bear, and he took over from that. But not long before that, he had a problem with his own colleagues. And for the very first time in the history of our own judiciary, you had about 14 of his colleagues really putting their foot down and complaining very bitterly to the hearing of the public that he wasn't managing the affairs of the Supreme Court very well. And even the issue of the handling of their own welfare, the infrastructure, the facilities in the Supreme Court, it went so bad that there was a round of appointments to the Supreme Court that couldn't be completed because they said there were no residential accommodation for justices of the Court of Appeal that were appointed to the Supreme Court. And those justices, many of them had to retire without the opportunity of going to the higher bench, which is the Supreme Court. So you had that. And I think the problem he had was also that of his health. And because he wasn't that really strong, I think they said his family took advantage of that and infiltrated the registry and mismanaged the affairs of the Supreme Court. So if you ask me, that was a precedent that I would say we would not want to go to again. And I think his successors, the first two of them, are learning from that and would have tried as much as possible in order not to step on that banana peel.
Etienne, thank you very much for speaking with us. We appreciate your time. I guess it's time to say may his soul rest in peace.